5A, review and reconsideration of the Planning Commission decision to revoke a conditional use permit for on-sale general alcohol and live entertainment in conjunction with an existing restaurant at 1332 Hermosa Avenue, the establishment. Your report is from Community Development Director Robertson. You have a supplemental letter from the attorney for David Lowe that was received September 22nd. You also have a supplemental letter from Sam Perotti received yesterday.
All right. Hello.
Hello. Good evening, Mayor and Council. So it looks like I need to catch up with you guys. This is the material on this item in paper form. I should probably, we need to get myself a laptop.
Is this what Craig wanted in one PDF? Do you really want?
Yeah.
Anyway, sorry, I had to say that. I'll have Tom follow up with you, okay?
So anyway, I'll give you a summary. I won't try to cover all this material. So back at a public hearing in May, the Planning Commission, on a 3-2 vote, revoked the establishment's conditional use permit for on-sale alcohol and live entertainment in conjunction with a restaurant. This decision was based on the necessary findings for revocation in the municipal code and on well-documented continuous violations of the explicit requirement in establishment CUP to provide certified and audited quarterly reports of their proportion of food sales, and also related to their lack of cooperation with a city-hired auditor to verify compliance with that specific condition. Even though the establishment had been out of compliance for quite some time, the Commission in March, 2 months before the public hearing, gave the business an additional 60 days to comply with this condition before they held the public hearing, and no progress was made in that 60 days. The Commission also indicated strongly that this lack of verification compliance relates generally to the question of whether this business is truly being operated as a restaurant pursuant to their CUP. As is clear in the record, the establishment and their legal counsel disputes the city's determination that they are in violation, and that's also documented in the record and in the recent correspondence from establishment's attorney. While there was some indication of a willingness to comply, it was only partial and ineffectual. The submittal of summaries provided without any corresponding examination of the records was not sufficient to satisfy the city's auditor or the condition. As further discussed in our report, establishment also had other violations, but as the record shows, the real significant violation and the main reason for the Commission's action was due to their continuous refusal to cooperate with the city's auditor and provide the necessary information that he needed. So given that this violation is well documented, staff really believes the issue that at hand for the council is whether the Planning Commission's determination to revoke the conditional use permit is the appropriate response or the appropriate penalty, given that other options are available under the code. We believe that this really should be considered in the context of two important broader considerations. First, both community development enforcement staff and the police department, as well as the fire department, have not found consistent, significant adverse impacts associated with the operation of this business. The business has cooperated with enforcement efforts related to noise, monitoring dancing. The business already has limited hours. They're subject to closure at midnight. We haven't had any problems with that. And the midnight closure was due to imposed modifications on the business in 2008. The business has a full-service food menu. And so while there has been some, as documented in the record, problems, they have been relatively minor. The second broader consideration is, as you all know, the city's municipal code has changed since the condition in this CUP was written, and it also has changed since the city started the audit process on this business. So restaurants are no longer explicitly defined as or required to have a certain percentage of food sales. 50% is still a benchmark or an indicator in our code, but is not the determining factor of what makes a business a restaurant. It's one of the tools we use in evaluating an operation that has other problems and other violations. So our position and recommendation remains consistent with our recommendation to the Commission. We believe other options should be considered, commensurate with the magnitude of this violation, which is essentially just related to reporting. So our what we think would be appropriate would be to modify the conditions in the CUP to help ensure operation of a true restaurant use rather than a nightclub, and or update the food sales reporting condition to be consistent with the current municipal code. And I also want to finally point out that since this process of reviewing this business has begun, the property owner has been duly notified and stayed involved in the proceedings. They have not objected to the city's enforcement efforts, but I think it's rather obvious to say they do not believe it's fair that this particular tenant's lack of cooperation related to sales reporting should have such severe consequences on their rights as a property owner, especially since they apparently are seeking a new tenant for this space, a quality restaurant operator. So that concludes my comments unless there are questions.
All right. Questions of my colleagues. I actually don't see anybody has pushed the button.
I don't have one to push.
Okay. I'm going to look to my right and I'm going to look to my left the old-fashioned way. Okay. I'll give you time. Mayor Pro Tem, would you like to ask any questions?
Thank you.
There we go.
I think the electronics also, if I'm looking at the staff report, it doesn't give me the option to speak, so I have to go back out of the staff report. This
It's my
is
way of making the meetings quicker.
Okay. First, I wanted to give a quick disclosures. Just want to disclose that I've had conversations both with Dave Lowe and with Mark Ballor over these issues over time. Obviously, this has been going on for a long time. And also that Dave Lowe was attended the first community meeting that I had Saturday. I don't think there was much discussion about it, but I know he was there for the meeting. And also wanted to disclose that during my campaign about 2 years ago, Mr. Ballor donated $250 to my campaign, and he Ballor and Associates owns the building where that facility is. So I just make sure the disclosure is out there. With that, the two questions that I have is, can the other restaurants that have similar requirements, do we have a difficulty with them complying with these requirements or providing the information to the city?
There's only one other business that has the exactly same requirement for a CPA to provide the certified audits, and that is the Standing Room. Since they've reopened that business, we have not had problems with them providing CPA certified reports that specifically say they are examining the records for their accuracy.
Okay.
Waterman's, well, they don't have, Waterman's and Dio de Campo have similar provisions, but they are not required to be certified by an accountant, and they are complying with their reporting requirements as well. But those are more like summaries of their own records without audited records.
Okay. And then there's reference in the staff report regarding code violations, and my question is, what is our current status of code enforcement in the city? I guess the question is, if we're not seeing code enforcement, is that because of our lack of visibility of code enforcement in the city, or is that we feel that the people are actually complying with our requirements?
No, our status is still, we're still pretty rigorous out there, ensuring compliance with conditions. We did lose our code enforcement officer and have recently hired a temporary replacement that is being trained. He just started this week.
Okay, and that was my question, is whether or not we have somebody filling in that gap.
And we have an open recruitment to replace that position with a permanent code enforcement officer.
Okay, that concludes my questions.
All right. Councilmember Tucker.
Ken, you mentioned that we've changed the conditional use criteria as to when 50/50 would start. If it had so many CUP violations and we require a 50/50, we can require that, or?
Yeah, the new code requires that they maintain records, but we don't invoke any audit or authority to review those records unless they are the subject of a CUP review hearing, which is triggered if they have other problems, other code enforcement issues that bring them up to a CUP review process. So under the current rules, we would not audit anybody and we would not bring up someone for review just on an issue of their percentage sales.
So these proceedings started before we changed the criteria rule. So therefore they still have a violation.
They still have a violation because their conditional use permit specifically requires the audited records be submitted on a quarterly basis.
Okay, thank you, Madam Mayor.
All right. Okay. So at this point, I will open it up for public comment. Why don't we let the business owner, would you like to come up and speak first? Or you don't have to. I want to give you the option since we're talking about you.
Well, I can defer to. So I'm sure you've got plenty to do. So I basically just wanted to read a statement into Mayor or Councilmember Tucker's question about where it was in the process. I think it was in May, and I think you guys changed the code in April, I believe, 2015. But anyway, I'll just get into this, and it may go slightly over 3 minutes if you'll indulge me. I started a restaurant in the city of Hermosa Beach in spring 2005, a little over 10 years ago. We took over a space. It was a Tijuana-style restaurant, TJ Charlie's, and invested over $1 million to remodel and redesign the space. We tried at the time to cater Hermosa Beach's high-end clientele, riding high in the real estate market. That effort was a great success until late 2007. We obtained several overcapacity tickets in December of 2007. At that time, Sharky's had burned down, and our volume greatly increased, causing crowd problems at our facility. Almost exactly 7 years ago, in September 2008, it was decided to modify our CUP and 2 others in the city at that time. That was the day before the start of the Great Recession with the collapse of Lehman Brothers. To put that in perspective, that was before President Barack Obama was sworn into his first term of office. You can imagine the hardship of cutting hours to midnight, not allowing cover charges, limiting live entertainment, and adding a 50-50 reporting requirement. At that time, it was suggested that I should just go out of business. Instead, I decided to dig in and fix issues. One of the major changes I made at that time was no longer hiring managers to operate the restaurant. Instead, myself and my brother was present every day, 7 days a week, over the last 7 years. Those changes caused a drop in revenue of over $1 million per year and left us deeply in debt, but with no police or fire issues. Since the original modification in September 2008, there has been 0 police or fire issues at establishment or our previous restaurant. That is 7 years without incident. We also worked to obtain the contract to provide food 7 days a week to the Beach House Hotel room service from 4 p.m. to 11:30 p.m. In February 2012, the City Council, including 2 of you, voted to initiate sales tax audits, not 50-50 audits. They started with .705 and Cafe Boogaloo, going through active revocation hearings as a trial run of these audits. In October 2012, .705 had their CUP revoked after 7 large-scale fights with reports of guns discharged. In March 2013, Cafe Boogaloo was cut to midnight, not revoked, after a 1-year drug sales investigation, selling alcohol to minors in fights. In early 2013, they started audits on the 3 places that had it in their CUP with an eye to audit all 16 late-night places. Waterman's quickly reported they were not 50-50. No one cared and ended the process there. The Shore also sold the standing room at that time and ended their audit process. We sat down with city management and staff on December 30th, 2013 and came up with a list of documents to finalize the audit. On January 15th of 2014, we provided those items related to the 2012 financials. On April 8th, 2014, the auditor requested items not on that list for 2013. A few days later, on April 15th, audits were put on hold until August 26th of 2014 while policy was decided at the council. During the time on July 4th, 2014 of that year, at 5 p.m., we had our front door open due to the extreme heat and received a ticket for an open door. Fortunately, earlier this year, the City Council decided to remove the 50-50 from the City Code and go with a more reasonable bona fide restaurant definition like the ABC uses. In the 10 years I've been a resident and business owner, I've tried to be the best citizen and business owner possible. I've been the president of the Hermosa Beach Hospitality Association since 2008. I've been both a board member of the Chamber of Commerce and executive board member in charge of business advocacy. I've led the charge to revamp the Fiesta Hermosa this year and improving parking in the city with smart meters. I've been on the Economic Development Committee and the Technical Working Group to revise the city's general plan. I've worked to bridge issues with carbon neutrality between businesses and residents. In 2013, I also was the head of the large coalition that successfully fought Measure B to close restaurants and bars at midnight. I'm a member of the Prevention Community Council to prevent underage drinking and have personally organized responsible beverage service training for 75% of the restaurant and bar staff in the city, including one this October 15th. I want to thank the citizens and the community for their constant support and patronage. I want to thank the landlord for working with us and being an excellent partner to find a reasonable solution to these issues. So no matter what happens tonight, our business will be closing. I'm asking you not punish the landlord or prevent the opportunity to bring an exciting concept to town. I'm hoping to recoup a small portion of the huge investment I've made in this community over the last 10 years, and I still believe this is the best little beach city, and I'm proud to call it home. So thank you very much for your time.
Good evening, Madam Mayor, council members, and city staff. My name is Mark Ballora, and I am the manager of Hermosa Pier Holding Company, LLC, the landlord of the building currently occupied by the establishment. I'm here tonight to ask that City Council does not revoke or modify the CUP that is presently tied to our property. We could have taken possession of the establishment's premises in February, and currently we have the ability to take possession at any time. Due to the controversy that this CUP revocation has caused with the city, we believe that it was more prudent to give Mr. Lowe time to sell his business. Throughout the last several months, we have been working diligently with Mr. Lowe and are now proceeding to sell his business to one of 3 excellent restaurant concepts that we are vetting. All of the potential tenants are excellent operators, all have food-focused concepts, and all of them are going to be investing in excess of $500,000 in improvements in the space. However, none of these potential tenants are willing to finalize agreements until they are assured that the CUP will not be revoked or modified with regard to the hours of operation. Since the Planning Commission's decision to revoke the CUP, Mr. Lowe's business has severely declined. Thus, he has only stayed open so that his restaurant could remain a viable asset during the sale process. Mr. Lowe has agreed to deliver possession of this space to me within a week if the CUP remains intact. I want to assure City Council that our firm's goals and interests are aligned with yours. We both want the best possible restaurant tenant for the space. The only way we can accomplish that is if the CUP remains intact. Please allow us as the landlord to take possession of the space and utilize the existing CUP to bring in an extremely viable restaurant into Hermosa Beach. Please work with us to accomplish this goal. Revoking the CUP will only delay this process, impeding the opportunity to bring a truly viable restaurant entity into the city and ultimately sending a very anti-business message to the greater business community. Thank you.
Good evening, Mayor Petty and members of the City Council. My name is Peter Pierce. I'm legal counsel for Mr. Lowe and the Night Restaurant Group. As Director Robertson mentioned, I had submitted a letter, and I don't want to belabor the points in the letter. I simply want to make one quick point. The condition 3 demarcates the boundaries of the documents that Mr. Lowe was required to submit, and it is our position that he submitted all of the documents that are required in the letter of the condition. After he submitted those documents, in a few months or perhaps a year and a half after he began doing so, further requests were made by the city for documents in addition to those that were required, and to a point he complied with those requests even though he was not required to do so. And so I think that that shows that he wanted to work with staff. That's the first point I want to make. The second point I want to make is with respect to the staff report. With respect to option 1 that Director Robertson has set forth, it seems that there's not really a nexus between the primary concern of the city here, which is the audit reports, and changing the hours of entertainment or changing the hours of operation. Seems to be more of a close nexus between the second condition, which perhaps is to require as a condition of the CUP, if it is reinstated as we believe it should be, to submit the type of information that was adopted in the ordinance back in April, and maybe it's more appropriate to tailor the CUP to that condition. If the council has any questions, I'm happy to answer them. Okay. This is the first time in my career as a lawyer that I've spent less than 3 minutes at a podium. Thank you.
Well done.
Hi, good evening, Cheryl Main, Palm Drive. I'm not here to second-guess the Planning Commission or to support the establishment, although I know Dave. I'm a big fan of his. He's been really engaged in the community. He's helped me in many ways answer questions, and he's just a good guy. But that's not the point. The point is we need to level the playing field here. We need policy that is actually policy. it depends on who stands in front of anybody, any city council, as to how we decide punishment or, you know, when you look at the facts, and the facts are in these documents, you know, I'm looking at, okay, Abigail's had an assault and a noise problem. And then American Junkie had 3 problems, but one was erased because it was dismissed because the officer waited too long to file. It doesn't mean it didn't happen. It happened. It's just that, you know, it doesn't go on the record. Then we have an assault at Patrick Malloy's. We have an assault at Sharkey's. But then it says there were actually 2 assaults, but one assault is not indicative of a lack of adequate security. My point is that we call out a business because somebody in a bikini hula hoops on top of a table, and we decide that that constitutes a nightclub, and that's a violation. But then we have people getting their butts kicked, or brawls, or girls being roofied, over-serving. There's a lot going on. And I think we need to focus on, you know, what is the end game here? What really is our I know the focus of the residents is to get, you know, people to realize that there's a lot going on, and we can stem it by having, you know, a little more of our police presence, and also to make sure that people have some accountability along with the enforcement. So, you know, again, it's a shame to see a businessman say that they're not going to be in business anymore because, you know, they just can't make it work here. And then we let other people do crazier things. So I just urge you, we need to find some policy that actually works for this city and the residents. Thank you.
Good evening. My name is Shane McColgan. I've been a principal partner with Dave and Mike Lowe, an establishment restaurant, since its opening in February 2012. I'm standing up here tonight to be a voice for the Night Restaurant Group and to help protect the integrity of our CUP. When I got involved as a partner, my main focus was to help assess the operations of the former business and make recommendations for the new one. I'm not going to waste time up here going over the facts, whether we are or not a bona fide restaurant, but I will say that I will take full responsibility along with Dave Lowe, and I apologize for any information that you feel wasn't provided to you in the past that got us to this point. I ask that you could reconsider to modify or revoke our CUP, as we are in the process of selling and very close to validating a sale contingent upon the outcome of tonight's meeting. Please don't penalize the Ballore Associates, the owners of the property, and the new prospective tenants. Thank you for your time.
Okay, I don't see anybody else. Oh, please come forward.
Mayor, City Council, Ron Newman, Hermosa Beach. I just wanted to say, if the ABC asked to see your books and you didn't show it to them and they wanted to punish you, the most they would do would maybe give you a 1-week revocation where you couldn't sell alcohol. They wouldn't take your business away from you. They wouldn't close you down. They would give you a penalty. And whether it's a week or 2 weeks, that's still very costly, but it doesn't take your business or your property away from the property owner, and it doesn't put someone out of business. Thank you.
All right, please come forward. I saw a few people. Quicker.
Mayor, Council, Sandy Seaman, Hermosa Beach. You know, listening to all this is probably what police officers listen when they pull people over with huge violations for speeding. It's all a bunch of spin. This commission here on August 24th ordered all 3 of these guys up here to get him in here, get his numbers, and make him comply. And all this about there's no 50-50, and it's not in their licenses, and the ABC doesn't do it. It's a crock of baloney. They do enforce it. I've told you to call Beth Goldberg and Richard Cravens. 50-50 is alive and well. It's built in every Class 47 license. And then you changed that night the restaurant reading, and it says if you're not a bona fide restaurant, we can audit you. And I think Councilman Tucker, or maybe Mayor Tucker at the time, told all three of these gentlemen to continue because that's what was on the books and that was the law. And that was August 24th of last year, and we're here today. And mysteriously, this thing's been put off time and time and time and time again. He's here because he stepped on his own foot, and it was very simple for any business establishment, bar or restaurant or otherwise, to give these numbers. They're built right into the registers. There's no problem. The landlord let this go because he got all the money illegally from all the illegal amount of alcohol that was being served and overserved over 50-50. And he profited by it. When he has in his lease, he could simply have sent him a notice saying you have to comply by all state, federal, and local levels, or he could terminate his lease. So he participated in the failure to get the job done. The manager signed the endorsements by Ken to say, now let's come back and rewrite the books. Let's forgive it all, forget it all, and let's not even consider all the other people that have to do it in the license, and then tries to tell you it's not alive and 50-50 should not be enforced. This council ordered a mandate for the audit on August 24th, and the chief of police wrote this letter. Now, if this isn't a violation of the law, and for him to do it, which he didn't, I don't know what is. So I don't think staff has the right to have an opinion, which really is a sixth vote here on the council of what they believe that they should do. We believe that we should do this. Now, thank God Ron came up here and told you that the ABC would violate, suspend you. But they would do more than suspend you if you were over 50-50, and if you didn't cooperate. They would take your license away and have a revocation. So staff shouldn't get opinion or a vote. They are a fact-finding enforcement body. They are not a sixth vote on this council, and you should uphold the Planning Commission and your own directives, because if you don't, then nothing has any meaning, nothing has any respect, and we'll continue with like 600 violations of DUIs, drunk driving, fist fighting, like that lady said, and this will continue. You need to uphold their decision and uphold this body. Thank you.
All right, anybody else? Please come forward. All right.
Hello, Ryan Bozan, 89 15th Street, Hermosa Beach. Good to see all of you. I'm very excited. Stop raising your hand. I want you to look at me. No, I'm kidding. All right, so yeah, I'm excited. I'm not going to repeat the sentiments here. I mean, they're great business. And if you watched the Planning Commission video from May 19th, you will see the overwhelming support from the community. Everyone believes that this is a great business and exactly what you want. But I was watching that video, and it was clear that the Planning Commission had their minds made up before the video even started, even with all that support. In particular, the three people that voted for it, it was all that, they did not comply. They did not comply. Like that guy right there. They did not comply. They must go. We must shut them down because they were not in the law. In particular, Ken Allen can't wait to get a new tenant in there and said, I quote, when they come forth with a new tenant, maybe they have a great tenant, maybe they go to 2 in the morning, for all we know. Really, Ken? You decide what a good tenant is. The support is clear from this room that we love this establishment. Ken Allen continues, you don't see people like Ron Newman or the Sanfords violating their CUP. They follow their CUPs to the letter of the law. Well, they're totally different CUPs, as the lady before spoke against. There's no uniform CUP. Do you think if Sharky's had to deal with 50-50, they go through the same It might have been differently. I don't know. I think Kent's out of touch. And then Sam Parati, who couldn't make it, maybe his wheelchair's broken. I don't know. But his end of his letter, he said, his letter he submitted, in the 60s, there was a song, I Fought the Law. A line in that song was, I fought the law and the law won. If establishment receives no punishment, Dave Lowe can change the lyrics to, I fought the law and I won. Well, I have a quote for Kent and for Sam and the gentleman that just spoke. It's from Thomas Jefferson. He said, if a law is unjust, a man is not only right to disobey it, he's obligated to do so. We know that 50-50 is wrong. You guys changed it. So what do we do now? It might be too late for establishment. I love the place very often. And they're wanting to sell. So obviously you're not going to revoke it. But after the vote, you guys should put up for discussion, maybe extending their hours to 1 o'clock, giving them more competitive with some of the other bars and restaurants in the area. And next, you guys' job is to appoint planning commission members. I'm tired of looking at 5 angry old white dudes completely out of touch with Hermosa Beach culture, dictating my future. Can we at least get a female on the dais? I sound like Nanette right there. I think we can all agree that city council has benefited greatly with the added estrogen. Right, Madam Mayor? Am I right? I mean, at least now that Annette's gone. I mean, that's it. All right, thank you for my time. Oh, time.
Jose again. It's we can't be selective on tolerating rudeness. So you either tolerate it or let it happen. Thank you.
Okay, anybody else? Please come forward. And I will ask that people refrain from clapping. Okay. Refrain from...
I'm Kent Allen, one of the old white guys. And I've made... what I've done here in my career in Hermosa Beach, I've really tried to pick my fights carefully. This is, in fact, the first time in 38 years I've spoken before the council. I've never spoken to the council. This is an important matter, and it's so important that I decided to come and speak about it. I want to thank Sam Parati for writing that letter, because so many people are new on this dais that they just don't know the years and years of stories and promises that we've been living through. I want to thank Hanny. Hanny, you disclosed the fact that you accepted $250 from Buller and Associates. I pulled the records. I was disappointed, Carolyn, that you did not disclose that you also took $250 from Buller and Associates. You did not disclose that you took $250 from David Lowe, and you did not disclose that you took $247 from his corporation. I think at the very least you should recuse yourself for not bringing that forward. I think it's wrong. He did the right thing. You did the wrong thing. I'm disappointed in staff because staff has done everything in their power to minimize our vote. There wasn't even a bullet point on the thing. You buried it in a line. You said that you presented 2 options. One of the options was simply to sustain our decision. It's quite obvious what your agenda is. You're going to hear Dave Lowe speak again. I suppose you'll hear Todd Allen, who said he spoke at the May 19th meeting for Buller and Associates. He said, and to quote Pete Hoffman, he chose his words very carefully. He said, under no uncertain circumstances would David Lowe be gone on August 31st. I got news for you guys. It's September 24th right now. He is not gone, and I have a feeling he's not going away, because you cannot believe a word that David Lowe says. You cannot believe a word that the Buller says. Nothing they say. We already have evidence of them. We listened for years for David Lowe telling us that he would try to comply. There's a good article in the paper today, and I want to quote, I'll take the quote from Ken Robertson. He says, Community Development Director Ken Robertson has said that Lowe's objections in this regard are meritless. We know that all of his claims are meritless, all of his excuses that have been going on for years and years and years. At the very least, you need to do something. And to let this go, David Lowe is a scofflaw. We all know it. He doesn't comply with anything. As a matter of fact, he didn't even comply for the last 2 quarters. Standing Room complies. Dia de Campo complies. They could have been heard. Waterman's complies. And at the conclusion of the last meeting, I was approached by a very well-known restaurateur. He's sitting behind me. I won't say his name. And he said, "You did nothing wrong. It must have been hard to reach that decision, but you did nothing wrong." I received 2 calls from retailers in town saying, "Thank you, Kent. Maybe we can get a retail establishment." Thank you.
Okay, anybody else? Please come forward. And please, no clapping, no commentary. Thank you. Please state your name.
Hi, my name is Brian Hurley. I'm a local resident of the South Bay and one of the co-owners of the Hermosa Beach Fish Shop. I apologize for being underdressed, but we had dollar oyster night tonight. Don't need an audit. I'm relatively new to the restaurant scene here, and what I will tell you right now is that opening a restaurant in Hermosa Beach is a big challenge. It's a big challenge than we thought it was going to be for several reasons. The leases and in the city have gone up substantially, and it's really hard to meet some of the leases that the cost of some of these leases. And to be honest with you, the city has been perceived as having a very strict city to work with. There's a lot of hospitality industries that are reluctant to come into Hermosa Beach for that reason, and that's unfortunate. When you look at the foodie scene in Manhattan Beach, one town over, they've done a great job of attracting it. They have a food scene, and they promote it. They do things for the businesses to help grow it. They send buses to LAX, bring people in, bring people to the market area. If you go down here to the pier, midday, up to early evening, is pretty slow, especially on the weekdays. And trying to sell food and to maximize it, it's a challenge. So before you penalize the CUP, maybe ask you guys a little bit to try to help us as owners get more foot traffic in here so we can sell more food. If we can, I'm sure everyone would sell more, but it is a big challenge for us. So please take that into consideration as you look at the CUP, because we do need more restaurants down here, and we do need more foot traffic. So I thank you very much.
I'm apparently underdressed too, but it was hot today. Mayor, members of the council, staff, Julian Katz, 9th Street. I want to take a slightly different approach to this thing. Members of the city council appoint commissioners to help them do their work. That's the purpose of having commissions, is to alleviate some of the things you have to do. I've been a commissioner for 8 years in this city, so I think I understand the relationships. I think you have an obligation to give special attention to your commission and your commissioners. They are operating in your behalf, and so you have to assume, I think, at least to start, they are doing your work with your judgment in mind. So keep that in mind, please. They are your servants, essentially, and helping to do your work. Thank you.
Jeff DeClo, Hermosa Beach. I wasn't going to talk on this, but I do feel one thing bothered me in terms of the staff report when staff basically talked about this situation as minor violations, and I think what has come up here and what troubles me the most is that we've had an incredibly inaccurate portrait or caricature of what the Planning Commission did and the actions they've taken and the patience they've shown. I mean, I don't see how it's minor violations when somebody is basically has transferred their liquor license, has constantly been in violation of their audits, consistently in violation of their CUP, and the Planning Commission has been incredibly patient with this operator in terms of this whole situation. And I think if anything is shown here is their sense of frustration in terms of how this situation has occurred. And it really troubles me in terms of staff and the way that they've approached this. And I think it's been brought up tonight by others, and I just want to say that I certainly echo that sentiment.
Okay, anybody else? Seeing none, I will close public comment and bring it back to the dais. I'm sorry, you know what I'm going to ask? After this, if somebody wants to speak, get ready to speak, okay? Otherwise, when I say public comment is closed, it's closed. So please speak. And then I will close public comment unless somebody else is going to be standing there. Go ahead.
Can I speak? I'm Ron Pizer. I'm the present chairman of the Planning Commission. And I just have a couple of things to say. Is that I agree 100% with Kent Allen. And the second thing is that Sam Parati's letter should be read by all you guys before you make a decision. It is a very clear description of what the Planning Commission has been doing in regard to this item. And if you haven't read it, I have copies here for you. But it's very important because it's like a little... It's a summary of what was going on, and it's the truth. And the Planning Commission has always tried to be honest with everybody. So I thank you.
All right. Anybody else? Please come forward. I'm looking.
Mayor Petty and members of the City Council, George Barks, Redondo Beach, Hermosa Beach. As you deliberate this issue, I'm not saying that Mr. Lowe hasn't violated some of the conditions that the City of Hermosa Beach has placed on him, but I think that you really have to consider the property owner in this case, and whatever your final decision is, it needs to be fair and equitable to the property owner. Thank you.
Okay. I'm looking. I don't see anybody. At this point, I'm closing public comment, and I'm bringing it back to the dais for deliberation. I am looking to see if anybody's pushed their button. Okay, I'm back to the looking to my right, looking to my left. What if I start to my right? Councilmember Tucker. Oh, I see a speaker.
I'll start with a question, Madam Mayor. I didn't get a chance to ask it the first time around. Ken, I was a little bit confused between the recommendation I heard you make tonight seemed to be slightly different than the recommendation that was in the staff report. Can you just clarify that for me? Are you changing, or am I just, I wasn't maybe reading the right? Did you change the recommendation, or the staff recommendation still consistent with?
It's the same recommendation. I mean, the staff report basically presented it as staff recommended alternatives to the Planning Commission decision.
And it's the two options that you listed. Okay. Okay.
Of course, embedded in the first option, there's a lot of possible choices. Right.
Thank you, Madam Mayor.
Okay, Councilmember Tucker.
Thank you, Madam Mayor. As has been pointed out, this has been going on for a long time. And we've asked, I was promised an audit from Mr. Lowe right from that dais. We never got what we wanted, nor was it ever submitted. Regardless of the fact that we changed the law does not excuse you from the violation. I'm not quite sure how that plays into it. I don't think in a court of law they say, well, the city changed their law. Well, they're still going to prosecute you for a violation you had previously. So this council has tried to get the downtown under control. We've had 2 or 3 other establishments, so to speak, that have had their hours rolled back and were required to put in a quarterly CUP, which they've done consistently now, as we heard from Ken Robertson. We've heard that there's a possible sale of this property. We don't know. This could go on for a long time. The property owners of this property have probably taken a little more proactive role in trying to move that along. Where at Boogaloo's that didn't happen. The property owner there didn't know anything about it when the hours were revoked. So somehow we need to get some resolution to this, and I'm not sure that complete revocation of a CUP is what is in order. But I feel there's some kind of a resolution we can impose on this business as a temporary measure to move forward with this and possibly still preserve the rights of the property owner. So those are my comments for now, Madam Mayor, and I'll wait to hear what the rest of my colleagues have to say.
Okay. Councilmember DiVirgilio.
Thank you, Madam Mayor. I largely agree with Peter. I'm not even sure I disagree, but let me say it slightly different. I think we could get into a lot of the details on the facts. I'm not sure I agreed with a lot of the characterizations really on either side. But what I'm clear about is that given that we were changing the rule, and we have since changed the rule, and that given that there were other options on the table, I think we got heavy-handed in this instance, and I think there's a more appropriate fit. I think there's a more appropriate fit of punishment for the crime, if there's a crime. And I think we have been patient. I think the Planning Commission has been patient. But I think it's in our best interest to not take this personal, but to be very clear. And we have not been clear as a community. We have not been clear as an organization for many years about this rule, and we're now clear. And I think that my understanding, my relationship with the property owner, is that they are trustworthy. And I have several experiences with them with our other dealings in town, where I see and I get what I'm told I'm going to get. And I think we heard something tonight that they're in the closing days of a transaction that resolves this. And do we get the satisfaction of having punished somebody? Perhaps not. But I don't know. I know a lot of business owners, and if your business if you've gone out of business, that's quite a punishment. Now, whether our reaction to this rule or not had any impact on that, I do not know. But when you're losing your business, that's a punishment of some kind. And I think that we have an opportunity to deal squarely with the property owner and to set up this evening's conclusion on this item in a way that confirms our interests and holds the property owner to a very tight account of what he told us tonight. And I think that I'm prepared to agree with option number 2 as recommended by staff, but we won't actually finalize that until the property owner has completed sort of his half of the bargain. And I think that would be fair. It would be fair for the future of that site. It would be respectful of the property rights. And the change itself, I think, sends enough message that we're not going to tolerate the abuse. We have tolerated it for 18 months, the extensions. I think another week, another 2 weeks doesn't send any other message. And I think hanging somebody for something that doesn't match it and isn't matched and isn't as aggressive as other things that we have done and taken action of, or other things that we have seen done and not taken action of, I think this would be appropriately fit. And I think we need to resolve this. I think we need to move on. I think we need to stop taking this issue so personally. And I think we should set up our language this evening to deal with the property owner. We had success, though a different approach, as Peter pointed out. I think we got what we wanted in the end at Boogaloo. And I think that we can. I think we've learned from that, and I think that we can do this right this evening. So I'm prepared to make a motion, Madam Mayor, if you're willing to entertain that.
Yeah, please go ahead.
Okay. So I move that we approve staff recommendation 2 and direct staff to report when they come back on this on the status of the property, and that'll be contingent upon our discussion that night to actually change that CUP in a way that works for both us and for the property owner.
All right. Is there a second? Well, what I'll do is I'll second it for further discussion. So, Mayor Pro Tem Fingeri.
Thank you. First, I wanted to thank and acknowledge Dave Lowe for everything he does for the community. I listened to what you had to say. I've been obviously in various of these events and things and functions that you've done. So I hear some references that suggest something's personal about this. Nothing about this is personal. I think everybody that has worked with Dave or interacted with him knows he's a good guy. He does a lot for the community, and we appreciate that. I think for me, the issue is that we have rules in our city that all other businesses are required to comply with, and we have staff that we've asked them to enforce these rules, and this process has taken years to get us where we are today. And I'm not going to get into the details of what was requested versus what was provided, but at the end of the day, staff has reported to us that they feel one of our businesses was not complying with the CP requirements. The business was given plenty of opportunity to respond and correct and modify and resubmit, and here we are almost 2 years later, and we're still dealing with it. I also agree with the comments that were made about the respect for the commissioners that we have that helped us go through this process. They have a lot more history in this process than we do, especially me being newer to this. A lot of them that have been dealt with this, at least have dealt with this issue at least for the last 2 years, but some a lot longer than that. I think Sam's letter goes back to 2007 or 2008. So this goes a long time. So I think, and with that background on the establishment, I also agree with Councilmember DiVigilio's comments about the property owner. We want to continue to enhance our restaurant base in Hermosa Beach and attract some of the places that Manhattan Beach has been able to attract. I know Ballure and Associates are talking to various people that can come in and fill this space, and would like to be able to give them that opportunity. Don't want to. And I don't want to use the word punish, because I don't think the goal is not to punish anybody here in this process. We just want to make sure our rules are being followed, and that there's a precedent set that once we have rules, that the rules are complied with. I'm not going to support the motion, because I think the motion is too lenient based on where we currently are. But I'll look for staff to give suggestions, either as timing issues, deferring this to a later time, or having a condition that would come into effect at a certain time later when Ballure and Associates have a different tenant available, or when they get confirmation that the existing business is no longer operating. I just have a concern, even though I trust the Ballure Associates representations based on the negotiations that are currently ongoing. I don't have a confirmation that on an X date something will happen. I'd like to see that, or I'd like to have something that put in place to allow us at that date to have that discussion if it didn't happen. I just think that I hate the references that Hermosa Beach has a reputation of not being business friendly, or people don't want to do business in Hermosa Beach. But I also don't like the reference it's Hermosa Beach. People can do whatever they want because it's Hermosa Beach. So there's a balance in between, and here where unfortunately we're too far on the end of that balance because we've been dealing with this issue for 2 years. I guess I'll send it back to staff as suggestions or thoughts. Is there something that we can do that maybe it's on the staff report that gets us in a position where we want to impose this at some point, but have it deferred to a later time to allow the landlord to continue their negotiations and dialogue with the existing potential tenants? I know we've continued this hearing a few times, and during that process, at least I was hoping that maybe something would resolve itself, and therefore we won't have to have this hearing. But here we are. I think the Planning Commission decision was in May. Is that right, Ken? So here we are in September. This is several months later. I just like to put some closure to it, and I'm just looking for ideas from you if that's something that can be done.
Yeah, I think the problem with continuing it is the action of the Planning Commission would stand, which would be the revocation, which means they can't sell the business. And so if you continue it, as I understand it from the property owner and the business owner, that's a problem because the Planning Commission action stands. So I don't know if there's something.
Continue this hearing without making a decision, then Planning Commission
correct
stands.
Correct.
But I thought we continued the meeting before several times.
Well, if you
I just-
continued it, you'd still have the same problem that we've had, which is they have a conditional use permit that's been revoked by the planning commission pending a determination by the council. So the problem they've had with selling the business continues.
Oh, I understand.
I don't know sort of what an in-between would be. You know, the property owner, you know, asked to not modify the conditional use permit either. The problem, you know, of saying, all right, well, we're not going to revoke, but we're going to come back in 6 months and see how it's going. Well, there'd have to be cause to revoke at that point. So it's a long way of saying I don't know that there's an easy one out of this. Ken or Mike, jump in, but
Can we impose the conditions on option 1, I think, on the staff report? Can we impose the conditions on option 1 in the staff report for a certain duration of time? Can we say that we're going to modify the CUP for these conditions for the next 60 days? And that comes back to us in 60 days for an additional hearing, and then if there is a different plan from the property owners who the operators are going to be, then we evaluate this and reverse it back?
you could do that under option 1. Again, that may, the property owner, business owner would have to address this issue, but that may impede their ability to sell, but that is an option that you can do.
Okay.
What about this? I want to make a few comments, but because we were talking about in between. So both of these options require staff to return with a resolution at a future time, okay? And so the question is, if that, either of these actually, but let's say it was number 2, if staff came back with this resolution at our next meeting, or however soon it would be, how soon would it be if you came back with a resolution?
At your next meeting.
At the next meeting. Is that enough time for the sale to move forward in the in-between time? Because what Mayor Pro Tem is asking is the assurance that if we came back, because that's when this would become final. And so in 2 weeks, if that did come back to us, if at that time there was something that assured Mayor Pro Tem that the sale, the transaction had happened, then I think that would assuage some of your concerns and some of my colleagues' concerns. Do you want to come up and speak to that?
And also, well, on that thought, does it have to be on the 13th again? Can it be in 2 meetings from now? I mean, could it be 30 days instead of 2 weeks to get the resolution?
Yeah, I mean, if you directed us to bring back the resolution at a different meeting, we could do that.
You know, just to follow up on your comment, I'm not overly stuck with a 2-week period. I just want to have an actual resolution where we're comfortable where we are, where we actually have information, rather than wishful thinking, which I think I'm happy to hear it, but I just need to get some kind of confirmation. But I'm not overly excited about having to be done within 2 weeks.
I don't believe we're going to be able to sell a business and finish up in 2 weeks. The people who are coming and looking at this are even looking to us to remodel the facade of the building. They're looking to put some of them up to $1 million. They have their architects walking through. They have their general contractors walking through. And it is not something that can get done in a 2-week or 4-week period. What I can assure you, though, is that the landlord will have possession of the space based on our discussions with Mr. Lowe. I suggested to Mr. Lowe that he gives me possession tomorrow if that CUP is not revoked. And he asked for a week so that he can give enough time, enough notice to his employees. So that's something that I can promise to this council, that I will have within a 1-week period possession of the space. If Mr. Lowe denies me possession of the space, I have a court stipulated judgment that allows me to call the sheriff and have him locked out. I don't want to do that, but the agreement that we've made is that within 1 week, he will be out of the space. And that's what I can promise right now, so I don't want to promise any more than that.
Okay, thank you. Did you want to say something?
Yeah, I guess we have a motion on the floor. Maybe let me try a substitute motion. We really can't determine, and it's really not our privy to try to help negotiate a sale or of a business. That's really not what we're here for. We're here to help, yes, but We've been hearing about a sale back in August. So who knows? So what I would like to propose is this, is that we modify their hours of operation for 3 months from 11 to 11 o'clock from 12 midnight for 3 months. At that time, it'll revert back to midnight. And during that time frame, the business, as we know it today, will close. We will close them for 1 week as the ABC does. And I feel that's fair. That's something probably the ABC would do, but it also sets that we need to move forward with this. We've always talked about 11 or 12 o'clock closings of restaurants downtown. We did this with Boogaloo. They came back, and really we rolled them back to midnight, and they ended up with 1 o'clock when the new owners came in. So I think a 3-month period does not take away the CUP. It allows you to negotiate saying, you know, in 3 months we'll be back to midnight. And there again, if they want to come in and move it forward, that's up to them. And we will suspend the business license, or however we can do that, of the current business for 1 week. So that is my motion.
Okay. There's a motion on the floor, a substitute motion. Is there a second? Seeing none, the motion dies. Okay, so I'd like to make a few comments and just a few questions of clarification. So,
Madam Mayor, pardon me. There's still the first motion on the floor.
oh, absolutely,
I just
absolutely,
want to make sure you didn't forget.
absolutely, yeah, that was a substitute motion, absolutely. So, Ken, I just wanted to make sure something was clear. This whole situation was triggered by a noise violation and the 2 quarterly records that weren't turned in, and that prompted the 3 violations, correct? And that's what triggered this entire situation? The 3 instances?
That triggered the Planning Commission bringing it up for review. Right.
Got it, okay. Because it was brought up in the audience, what's the process? And that is the process. When there are 3 violations, and that is when the conversations start. But something that's key is something that actually Dave's lawyer brought up, and it's this consideration of nexus. So basically, and Councilmember DiVirgilio alluded to this too, basically, the punishment has to fit the crime. There has to be a nexus. So as an example, the two violations here, one is a noise violation and the other is not providing records. So as it relates to a noise violation, the nexus associated with a breach of a noise violation would be something such as removing their ability to have entertainment. Just, let's say for one noise violation, an appropriate nexus might be if they had an entertainment, and I don't even know if they do, but if they had entertainment, the nexus would be for one violation, you cannot have music in your establishment for a month or 2. After repeated noise violations, a nexus would be you no longer have an entertainment license. That's an appropriate nexus. That's an appropriate cause and effect, punishment fitting the crime kind of scenario. That's important because what's happened is the conversation has turned into going into an entire history of everything that's happened. We got a letter from the commissioner, all the whole history of what's happened. But the reality is a conditional use permit is a property right. And there are actually laws governing when you yank away a property right. And we can't just yank away a property right without there being an appropriate nexus, an appropriate relationship to the violation that's been committed. So that's the way it's supposed to work, okay, when you have something like a noise citation. Now, getting to the paperwork issue. The thing is that many people use the term audit loosely. An audit is a technical accounting term that refers to a certain activity that takes place. And the problem is that in this case, the word audit was put into his conditional use permit. Well, I will just let everybody know from a boring accounting note, there's 3 ways in which you can actually evaluate a business. The cheapest and the easiest thing that an accounting firm can do is they literally conduct a compilation where they're literally just putting together all of the information that they have and they present it to a city, let's say. The next level, and that's the cheapest, the next level is a review. The difference with a review is they put a little more scrutiny into what they are providing. A review can cost $5,000 easily for a company. A compilation is a few $1,000s. An audit is that next level of review. That takes months to happen. I've actually never seen a company that was ever audited quarterly. Companies are audited annually. That is a standard. And one of the reasons this happens is because audits take months to do. Easily they cost a minimum of $15,000. Now, it was interesting to me to hear that one of the businesses submitted something. I'm not sure if it actually was an audit or if it was a review or a compilation and people just didn't realize the difference. The problem is there is a difference. And we put in language of a financial nature into a conditional use permit. We don't really know what it means. That creates a problem. And in this case, it did create a problem. Now, something that was really disturbing to me was that the city hired auditor in an email asked if he could fudge the numbers to make the liquor sales higher. That's actually what he did. And to me, one of the reasons that you need a CPA is because they are certified. And they actually have an obligation to be as impartial as possible and to be honest, because if they are not honest, they lose that certification. They can no longer practice as a CPA. And so it's really disturbing to me. And to me, when we have somebody who's been employed by the city, who is not a certified public accountant, who actually says that, are we entitled to figure discounted liquor sales at full value for our computations? This would certainly raise the total liquor sales. That is highly disturbing to me. And what that says to me is this whole process that we've been going through of asking people to submit records and auditing their records, and then we have somebody who's actually sending emails to staff saying, can I fudge the numbers? So disturbing. It's really disturbing. And that's one of the reasons that the 50-50 creates problems. But getting back to the whole idea of nexus, what we have is a paperwork issue, and we have a noise citation. And so really, in terms of the scrutiny, or what the punishment that we're meting out, that's the question. Is it appropriate? To me, if we had over-serving issues, selling to minors, selling drugs, overcapacity issues happening over and over again, you'd want to shut a business down, and that is what we have done in the past. Those are reasons that you would shut down a business. But that's not what's happened here. We had one noise violation, and we had a paperwork issue. And so that's the perspective that I have, is that we potentially put ourselves as a city organization in legal hot water when the punishment does not fit the crime. And we will end up having potentially a problem, because a conditional use permit is a property right. Hours of operation are a property right. And so I support the motion that's on the floor. I think it's reasonable. I don't think it gets us into legal hot water, and it's also appropriate given the nature of the crime, which is not severe. So the other thing that I just want to note for everybody is the landlord is a company that we have been doing business with, and we will continue to do business with. And I don't think it's in his interest to misrepresent himself to us. And I know that there's been concerns about the property owner not really selling the property, but I don't think it would be in your interest as somebody who's doing business to misrepresent the situation to us. I don't see that happening. And so if that's the concern, that Dave is not really going to sell the property, I have to trust that you know that you're going to have a long relationship with us. You're doing many things in this city, and I believe you. The reality is that this will be coming back to us because the staff will have to come back with a resolution. But at this point, the concept of rolling back hours is going to create a problem because it is not in proportion to the situation that occurred. So, at this point, if there are any further questions, and I don't think I see, any more comments? Oh, nope, I see two speakers. Councilmember DiVirgilio.
Yeah, I think maybe I have a new view on my motion. I'd like to share it quickly. I want to ask a question of staff first, though. Mike, if we were to approve item 2 and staff returned at a future meeting prepared, with item 2 prepared, and it did not get a majority of approval that night, what would happen?
Well, a deadlock on the city council would essentially reinstate the decision of the planning commission.
Thank you.
Which would be a revocation.
Right. Everybody hear that? So, okay, I'll say it again. So my motion was to direct staff to return with a resolution to modify the condition, fit it to our other code and our current code and our other practices. This gives the property owner the ability to retain the rights and take action, as we heard him say this evening. I respect the concerns about what could happen if we were to approve the motion, as I've made it, and came back at October, whenever, and the property owner had a different story, and it didn't retain the property, we would have the ability to not approve the change, thereby meaning the Planning Commission decision would stand. That's our leverage. We don't need to create other maneuvers or temporary changes. That's our leverage. I don't think we need the leverage, but I don't mind having the leverage, and that's fair leverage. We're giving you some time to sort it out. You sort it out. We'll make the decision as is offered in recommendation number 2. If not, we have it within our power that night. In fact, it will require a majority to support. So a deadlocked 2-2 council even would mean we go back to the Planning Commission. I think that's actually incredibly fair for us, and it's reasonably fair for the property owner, who we have been fair for the property team for some time. I think a couple more weeks is a legitimate last-ditch effort of fairness. And so that's my pitch for option 2 in the motion. Thank you.
All right. Mayor Pro Tem Fangari.
I just wanted to get some clarification. I think Councilmember DeVille may have provided some, but just to confirm, option 2, all option 2 does is basically direct staff to essentially make the CUP, basically reduce the requirements of the existing CUP to make them more consistent with our new laws or code changes. So it's actually making it easier for the operator to comply with. So as much as what you were saying makes sense to me from a business relationship with a property owner, it concerns me that we are 2 years into this process, and we're asking staff to go back and make the CUP actually easier for the operator to comply with than it was before. So it seems like we have an operator that goes through for 2 years and doesn't comply with the city code, and have several planning commission hearings, at least 1 or 2 here before us, and the resolution that we have is tell the staff to make it easier for him to operate. I mean, I hear the business concept. I just, perception-wise, it doesn't seem to me that this is what we should be doing for businesses by having them continue to not abide by our rules for 2 years, and then just, well, okay, let's just change the rules to make it easier for you instead of having it. So, go ahead.
Well, I hear what you're saying. The reason I think that I have a different characterization of it is because the rule we would be changing the CUP to is the rule that we have in place for the rest of the community. And so we're not making up a new rule for them or giving up a rule. We're actually removing the rule from the CUP that's no longer consistent with the rest of our code. We're removing it. So I think you're right. It's easy. It becomes easier, but we've already, as a policy, sort of citywide, said we don't like that more difficult rule. We wouldn't apply it to anybody else. Dia de Campo doesn't have it. Who are some of the new ones? We don't have that rule elsewhere, and so it'd be consistent with our code. Thank you for letting me interject.
I appreciate that, and I think, and I don't want to go back and forth, but I think my recollection when we changed this code was, and our question to the city attorney was specifically, if we change this code, is that going to change the CUPs? And my recollection was it does not. So whoever had a CUP that was more restrictive, the CUP conditions rule, and the code would apply to everybody else. So in this case, I'm left with this impression that we're basically almost rewarding somebody for violating our rules for 2 years rather than, not that I want to use the word punish, but rather than something make it worse, it's actually being rewarded because now they're getting a CUP that's easier to comply with. And it's my recollection, Ken, that there is at least one other business that still has that CUP requirement. So we're giving, the establishment a way out, says, hey, you don't have to do that anymore. But this person that's complying with it what do we do with them? To go back and tell them now we're going to do a favor for you and take that out, or do they have to, for them to wait until they not comply with our rules for 2 years before we remove it from the CUP? It leaves me with a kind of like somebody's being rewarded for not abiding by our rules is the perception we're leaving with. I understand the business mind and I understand what you're trying to accomplish, but it leaves me with, if you want to get easier CUP rules going forward, just don't abide with them for 2 years and the council will come and make it easier for you.
Yeah, you know what, I'm just going to offer an opinion. He's going out of business. And please don't laugh. I mean, because it's actually unbelievably serious. He's lost his livelihood, okay? And if that isn't punishment enough, I don't know what is. He is no longer going to be in business. And so I hear what you're saying, but he's lost his livelihood. He's also a Hermosa resident. And so now the question is, if you want to get a quality operator and if you trust Ballure to bring in a quality operator. I mean, that's really at the point at where we're at because Dave isn't going to be part of the equation anymore. And so I wanted to bring that into perspective because I would say that he's lost his business. And so whether the way that the city treated him hastened the situation, the city might have played a role, and it kind of sickens me to think that, because it is your livelihood, and I think that unless people own their own business, they just have no idea how hard it is. But I didn't want to lose sight of that perspective, okay? You have to, at a certain point, trust the landlord that he's going to bring in the right kind of operator, but if we end up cutting back the hours to a certain point, nobody's going to want to take that lease, because a restaurant that closes at 11 might as well. A restaurant that closes at 11 has to start clearing the tables around 10:30. You probably take your last order of wine at 10 o'clock. People aren't going to go. I mean, that's just the reality when you go out to eat. I mean, at 10 o'clock, they're going to say, this is last call, and you've got to stop eating. At 10:30, we're taking the wine glasses off your table. It is not going to work. And that's just the realities of running a business. So I wanted to offer that. So at this point, did you want to say anything else? Please, feel free to as well.
I think I'm hearing the input that I'm getting from my colleagues, and I appreciate the input and appreciate the advocacy that's going on here. And I think a lot of people complain to us about our meetings go too long, but that's part of the reason why they go too long, because this is the only way we can communicate and try to convince each other that maybe that makes sense, or this is fair, or this is reasonable. So I think from the input that I've heard from the mayor and Councilmember DiVigilio, I am more inclined to support the motion with the clear understanding that, and I'm totally fine with this resolution coming back in 30 days rather than the next meeting, with the clear understanding that if things are not different by then I'm not going to be one of the votes that supports it. That then the option would be that the Planning Commission motion sustained, and that's where we go. And I think it's fair to the current situation. I understand what Dave Lowe's going through, and would like to give him an opportunity to get, an opportunity to get with him and his employees, get a more comfortable exit out of the situation. I want to give the property owner an opportunity to get appropriate operators. Again, I'm struggling with the perception that this motion gives, but I also understand the points that you both have made, and I appreciate that. And I think that's a fair compromise, and I will support it.
Okay, so
Mayor.
Yes.
So what I'm hearing from my colleague, Councilman Fingeri, is we're going to give you 30 days. Is that what you're saying? 30 days. This is coming back in 30 days, Ken? Is that what we're doing, or are we going to bring it back sooner?
I just want to ask a question about that. I'd like to ask a question about that. I don't know whether the answer will require an answer from the owner of the property. I thought I heard him say that Mr. Lowe would be vacating the premises within a week or so. I also heard the city manager say that resolution of this issue is important to the acquisition of the property by another operator, or acquisition of the business by another operator. So if your concern is whether Mr. Lowe is in or out of the property, and and the representation is that he's going to be out within a week, and you could have a resolution come back in 2 weeks, which arguably would facilitate the sale of the business quicker once this matter is now put to bed. If you wait 30 days or 60 days, then that leaves the situation in a state of uncertainty for that period of time, because unless the resolution is adopted, it's still up in the air, and according to what I heard, that would impair their ability to sell to a new operator. So if the representation is that he will be out of the premises in a week, and that is important to you, and it sounded to me like it might be, I'm not sure, then you might want the resolution to return in 2 weeks.
Madam Mayor, if I may, real quick. Mike, I appreciate that input. I think what I heard from the property owner, though, that assuming that it'll take a week or so for the existing operation to terminate, it takes a lot of other next steps for architects and contractors and chefs, and I think they're talking to 2 or 3 different people. So I guess my thought of having it 30 days instead of 2 weeks is to give an opportunity for this establishment to do what they need to do, to allow the property owner to do what they need to do as far as interviews and discussions and inspections, so that 30 days from now we actually have not just that, Dave Lowe's not there anymore. We have an action. Here's the plan. Here's what we're doing. It doesn't have to be a contract signed, but this is what we anticipate happening. And then we have a better story and a better, So, and I don't know that based on what the property owner said, I didn't think that a 2-week period is going to prevent anything from proceeding. I think it's going to take just that long for the various potential tenants to go through the property, for them to have engaged in discussions with all 3 of them, 2 or 3 of them. So I guess the short answer is I can go either way. I thought 30 days is actually more helpful than 2 weeks, but I'm fine with either way. I see Dave Lowe raising his hand. Madam Mayor, if you want him.
One point of clarification is really no big deal. It'll actually be 3 weeks from last Tuesday will be the next time, so it's 2.5 weeks when you come back.
Could we maybe modify the motion to simply say by our second meeting in October, and then we leave it up to staff and the property owner to sort it out? And I think we would like it sooner, but if the month is workable, then that's the answer.
And Madam Mayor,
Okay.
Dave Lowe had his hand up. I don't know if you want him to give him an opportunity to speak.
Did you want to come back? Come back.
Really quick. I just wanted to reiterate what the landlord said. We're realistically going to be out of there October 6th, no later than that. So that's Tuesday, basically a week from now. From there, it is going to be difficult. So if you're expecting that a conclusion of sale is done in that period of time, it's not that quick. You have to transfer a liquor license. You have to get architects in there. It's going to have to come to the building department. There's going to be a lot of back and forth on that. So as far as if your concern is, if I'm out of business, that's going to happen quickly. If it's as far as getting the new person in there, and that takes time, and these people are savvy operators, I just ask that you work with Ballure and help affect that, because it will make a huge difference. It's going to get you a much better operator in the city. Thank you very much.
Okay, so are we done deliberating?
No.
Councilmember Tucker.
Having heard that from Mr. Lowe, he said by October 6th, and I understand that if he's out, yes, it will take a while to negotiate with anybody, and this idea that we got to hire chefs and this and that, that's not the important issue here. We've heard that Mr. Lowe said he'll be gone, and it's sad that he is, because he has done a lot in the community, and we don't disagree with that. I think October 13th is a week after the 6th. We can get a report from the property owner that Mr. Lowe is no longer a tenant, and then we can move forward with the property owner, and that's going to allow him, in my opinion, to secure someone else. Now he doesn't have to worry about the current business owner leaving. He'll technically be gone, from what we've heard tonight, and on the 13th everybody can move forward. That way they know, any person that comes in, because they're going to say, yeah, I want this spot, but it takes a while to develop plans, things like that, but at least the CUP is still in place, and that's the critical issue right now. So I feel this should come back on the 13th, and if that's the case, I will support Michael DiGiulio's motion that this comes back to us on the 13th.
Great. Okay, so with that, I will call the motion. All those in favor?
Aye. Aye.
All those opposed? None. All right, motion passes 4-0.
Could we take a quick break?
You know what, let's take a quick break, okay?